Hey everybody, it's Tracy, and I got an email from a crypto blog just a couple days ago, and the question was, what's my opinion on Tornado Cash? And I wanted to share it with you because I think it's relevant to sort of where crypto as like an industry is going and like how projects are legally defined. And first off, I think Tornado Cash clearly was a tool for money laundering and avoiding OFAC sanctions by various parties, in particular the North Koreans. First off, don't do business with North Koreans, and Tornado Cash could have easily avoided that, but they didn't, and that was stupid, right? Very simple. And the other angle, second angle rather, is the defense that was raised by the promoters of Tornado Cash, and there was two. The first one was smart contracts are protected by the First Amendment as like freedom of expression. And here's the thing. I'm by no means a constitutional law expert, but I know enough. And to say something, right, is protected within certain boundaries, whatever it is. Fighting words and stuff like that aren't. But to say, you know what, this guy, this politician, whatever, doesn't always do it, that's totally protected. A smart contract in like software, which is the thing, is different, right? Yes, it's like a written medium, right, in a sense. But unlike speech, it functions, right? A smart contract, even though it doesn't, once written, effectively doesn't need, nor could, have any sort of like human interaction or require human involvement, it still functions. And if something functions, then it could be subject to regulation. Speech doesn't necessarily function. So you draw the comparison to posting hacked passwords on a website. Well, is that speech protected? No, because it functions. Because through that, people can gain access, right, to other people's accounts. You wade into the waters of regulation. Well, this is seemingly like the defense du jour, any crypto enforcement action. Well, I'm protected by First Amendment. I don't see how it would ever work. And I think it's just naive, right? And I think a lot of crypto anarchists want to believe that it is and all that, and like the First Amendment allows you to do anything, but that's not the case. It's not the case at all. Number two, and this is probably more relevant for what I talk about here, and it's that the ruling came down outside of the First Amendment argument to was or was not Tornado Cash an entity, right? Because the question ultimately was, could the individuals be responsible and could crypto be seized from Tornado Cash? And Tornado Cash, without necessarily saying it was a DAO, was a DAO. And the judge in the matter ruled that it was an entity. And among the things cited, the reasons cited, the big point was the intent and the function of the smart contract. Because again, the whole defense was, oh, well, you know what? We started it and it's just running on its own. There's nothing we can do. That's nonsense. One, there was an intent to create the smart contract to operate in a certain manner. Right? Like, it's not a listless ship. It didn't come out of nowhere. Somebody did something, right? And created these smart contracts that operated or allowed Tornado Cash to function in the manner it did. And the second point relied on by the judge was the smart contract paid the promoters or this quasi-DAO, whatever they defined it as. I think they sort of changed their minds when they realized that they were in their defense. But it compensated the individuals who promoted Tornado Cash, irrespective of how little involvement they had on a day-to-day basis regarding its function or its marketing or anything, which was even acknowledged by the judge as being very minimal, right? Like, you had this core group of guys, they created the smart contracts, put them in place, and maybe there was some marketing effort, who knows, and it just took off, right? So as it went, yes, on a day-to-day basis, was there great involvement? No. But they did it, and they did it with a motive to profit or have some sort of pecuniary gain. if you want to draw the parallel, and like we're forced to because there's so little law out there, so you have to rely on decisions like this, which aren't even really precedential because they're lower court decisions. But for a DAO, we're never going to say this isn't an entity because it's smart contract driven, right? And I'm not talking about even like the Wyoming LLC DAOs. I'm just saying these unincorporated associations, which just take the form, and I've said this many times before, of a state level partnership, right? A general partnership, which in nearly every state doesn't require any like filing or anything like that. It's just a group of people or even two people who agreed to act in concert with each other, right? And that's what you have here. And like many DAOs, especially prior to the Wyoming LLC DAO, don't have like corporate structure, and it's like this unincorporated association. And there's this misconception that you can have this listless ship where nobody's responsible for anything. And we saw that in earlier cases where a lower court judge found every single member of the DAO, not just the promoters, right? The guys who started it and were probably raking in the lion's share of the money. They found every single member. So I put in $10. I'm a member of the DAO. I'm legally responsible for the actions of the DAO, right? And again, this goes back to, hey, pay the $100 and be a Wyoming LLC DAO. But it also speaks to the nuance of these DAOs in setting them up. You can't have a headless horseman. There's no listless ship, because no matter what you do, right? And this speaks to liability for actions like for hacks, for evading sanctions like Tornado Cash, for selling securities like MakerDAO, all these things. It's the fact that it took some concerted effort with a collective profit motive in mind to create this DAO, right? And once you've taken those steps, you are a DAO, and you are subject to every law there is imaginable under the books, whether it be in the United States or anywhere else, right? Gone into why the LLC format DAO is better for liability reasons, but you're not going to escape the fact that at some point in time, you took the effort and you took the time to have collectively put together a smart contract, and now you're making money from it, right? And even if you said, well, fine, we're doing this like for charity, I don't know if that even slots, right? Or there's no money to be paid back. Well, no one's going to actually join the DAO, right? I mean, just for like rational purposes. But at the same time, it's not going to help you from a legal perspective if you're selling securities, if you're not following OFAC. You can't exist in this vacuum, right? And I think this decision of Tornado Cash is like the death knell of that argument, hopefully, because it's so misguided. I can't, and I hear it all the time. Well, you know, we can't be held accountable for anything because we're this DAO. No, that argument's dead and done, right? Just forget it. So I'll get off my soapbox, but that's my take on Tornado Cash. And I think it's helpful because we lack so much guidance, like especially with DAOs, because they're new, right? But I think the premise and the takeaway is like, no matter what, you always have to remember the DAO didn't create itself. Somebody did something somewhere, and yes, you're governed by smart contract, but you didn't do it for free. You're not doing it for free, and you put time and effort at the outset to start it. So that's it. Check me out, Adam at adamtracy.io. Happy to answer any questions you have. I'll talk to you next time. Cheers.